honourable judges, members of the British Academy, fellow scholars and legal experts, distinguished guests, colleagues, students, ladies and gentlemen. It is a real pleasure for Yvonne and me to welcome you to the British Academy Conference on Challenges to Judicial Independence in Times of Crisis. We are very excited to co-convene one of the 6 conferences in the Academy's fascinating 2018 program. The other 5 conferences address subjects that span the arts and humanities, from the biblical traditions in the Quran, Maoism, and Burckhardt and the Italian Renaissance, to alcohol's social affair with humans, and global neoliberalisms. In fact, we feel very privileged that law was made part of this aesthetically super rich list of disciplines that the Academy's prestigious conference program is bringing together this year. In any case, long gone are the days, we think, that we would be investigating law solely in its black letter dimensions. Our subject has become acutely aware of the need for interdisciplinary approaches and for active synergies between academic scholars and legal professionals, so as to obtain the capacity to suggest solutions that will be grounded in evidence, that will consider the systemic, cultural, professional, institutional context within which these solutions must apply. It is on such synergies that our conference is investing today. We are very honored, we're very grateful for the support of the esteemed members of the judiciary and members of the wider legal community, the wider legal profession amongst us. A Justice of the UK Supreme Court, the former Lord Chief Justice, the former President of the Cour de Cassation and member of Conseil Constitutionnel of France, the former UK Judge at the European Court of Justice, current and former High Court judges, a member of the Parole Board, eminent barristers, a senior member of the UK's Army Legal Services. And of course, a number of renowned academics from the UK, from France, from the United States, from Greece, from Sweden, who are working in diverse disciplines, law, of course, UK law, international law, comparative law, but also criminology, politics, journalism, media studies, history, which bodes, we think, very well for attempting to define judicial independence and identify contemporary challenges to it from an interdisciplinary perspective. Now, Yvonne proposed the idea of the conference a long time ago, around the time of the High Court judgment in Miller. So her reflexes were wonderful. And in the process of writing the application, we received some very interesting feedback, some constructive feedback, the application to the British Conferences Fund. And one element of this feedback related to whether a debate on these issues, on judicial independence, on the case of Miller, on independence of the judiciary in view of Brexit, whether it would be timely, a year or a year and a half later when the conference would actually be taking place. So let's see. We were originally inspired to put the conference together as a reaction to Miller, case of Miller, important Brexit case. We were inspired by Trump. I mean, I don't mean that literally. We were inspired by Trump's attacks on the American judiciary, Turkey, and the seminal important attacks on the judiciary there. At the same time, the French government's attempt for greater control at the Cour de Cassation, which was happening around the same time. Now, the noise from Miller has to some extent receded, so the media's target has now been placed on those Remainer or Remoaner MPs, those labeled by the Daily Mail and the Telegraph as the saboteurs or the mutineers, and with the echoes of the post-Miller attacks on the judiciary being very strong indeed. Trump's attacks have not ceased. Nobody thought they would have. And in Turkey, thousands of judicial officials remain in Erdogan's prisons. No, the threats and risks to judicial independence have not receded. Quite the contrary has actually happened. The situation in Poland, for instance, which has caused great concern the European Union and the Council of Europe, provides a very good illustration. New legislation that changes the retirement age to 65 is forcing 40% of the 86-strong Supreme Court there to leave their posts. And at the same time, the government is obtaining control of the National Judiciary Council, which will allow them to effectively control the appointment of judges. We can see then that judicial independence is increasingly under threat, particularly as a result of the rise of populist and nationalist sentiment at home and abroad, which threatens to undermine the separation of powers, with judges being portrayed as elitist and enemies of the people, and governmental interference with judicial matters becoming routine. It is these contemporary challenges to judicial independence that we will seek to situate in a legal, philosophical, historical, comparative, psychological context. And it is in this process that we will have to ask some difficult questions over the course of this conference, normative, but also practical, empirical. Why is judicial independence important? It's a precondition for implementing the rule of law, in the sense of securing equality of treatment under the law, independent of political influence or status. And it's a factor, evidently, leading to economic growth. What are the conditions for addressing contemporary challenges to judicial independence? Here we might need to distinguish between de facto and de jure protections to judicial independence. A simplistic answer, for instance, might suggest that more legislation and formal responses are the way forward to securing judicial independence. But recent research, for example by German academics Gutmann and Voigt, indicates that informal cultural factors are playing a more important role. However, what happens where cultural factors clash with the need for reform, particularly where the pressures for reform come from outside of the system? The question of whether the French public prosecutor is an independent judicial institution, an independent judicial organ, provides an interesting illustration. The European Court of Human Rights has been insisting for a long time now that it isn't. Or what if, through legal reform, we take aim not at reinforcing judicial independence, but at diminishing judicial independence instead? And such seems to be the case in Poland, as I mentioned just now. Should we be relying on international law for protection in such a case? Or is judicial independence, at the end of the day, a matter to be decided solely in accordance with domestic law and practice? Similarly, we might need to think about the level of engagement of judges with politicians and with the public. How much is too much interaction? And what happens conversely if politicians disengage from the judiciary, or if the judiciary fails to engage with the public? Who should be the guardians of judicial independence is the next question that I think will naturally be raised in the course of this conference. In the UK, after the scathing attacks from the press on the High Court judges that decided Miller, many in the legal profession came to the defense of their judges. But the Lord Chancellor didn't. And this consequently led to an angry reaction from the part of the legal profession. Now, before reforms were introduced in 2005, the Lord Chancellor was the head of the judiciary and responsible for judicial appointments. And he was, or she was, historically seen as a special guardian of judicial independence. But the role since then has changed, and the Lord Chancellor now functions as Justice Secretaries would actually do in other countries. As Patrick O'Brien has written in an article published in Public Law recently, the Lord Chancellor lacks the cultural background, constitutional authority, and political incentive to defend judicial independence against a hostile media. This leads to wider questions about whether judicial independence has to be protected from outside, and using what methods exactly, or whether it suffices for the judiciary and the wider profession to defend their institution from within, even in times of crisis. But how can they do that in the face of fake news and personalized attacks by parts of the press? What can be done more generally to limit anti-juridicalism in the press? Does anti-juridicalism originate, for instance, in antipathy to rights, antipathy to Europe? Should we then perhaps start by trying to correct misrepresentations of the latter to defend against the rise of the populist threat? I hope that our work in the next 2 days will allow us to identify crucial, timely answers to many of these urgent questions. Once again, we would like to say a very big thanks to all our participants and a very big thanks to the British Academy for making this conference happen. Thank you very much.
Kind introduction, and may I first of all, I think on all our behalves, congratulate the two people who've really driven this conference, got it all together, and provided what I think is a very important interdisciplinary aspect of judicial independence. Because as was said in the opening, judicial independence isn't something, I think now, that it is only lawyers who think about. I think for reasons I'll try and explain in a moment, it is a much more wide-ranging subject. But what I thought I would try and do in the short introductory remarks and allow a little time for discussion, because you certainly wouldn't want to hear from me for a whole hour, was to say something about the overview as I see it. But I do want to say something by way of caution. I, as you know, have retired. And sometimes people think that when you retire as a judge, you're unconstrained. But as you will always see when they report what a retired judge says, they either pull out a picture of him in his judicial or her in their judicial robes, or secondly, a photograph which has behind you something which shows you are a judge. So you can never escape from the public perception you're a judge. And therefore I think it is very important that as a retired judge, one recalls one is still heavily constrained in the public eye by one's former status. And therefore I regard myself as bound by rules that really do preclude me from discussing beyond what I've already said, a case such as Miller. We have a very salutary rule in the Judiciary of England and Wales, and I think of the whole United Kingdom, that judges should not generally discuss their cases. It provides a salutary basis for progression in that if you decide a case and then you say something more about it extrajudicially, then you cause a problem, because what are your real views? Are they what's in the judgment or the gloss on it? But secondly, and equally importantly, it saves you being the subject of detailed discussion and questioning about a decision, which is equally important for protecting the decision that you've made. And thirdly, I think it makes judges concentrate on saying the reasons for their decision in the decision itself, and not hoping they can rescue it by some remarks later. And so I do regard myself as bound. But what I'm going to do, therefore, is give some reflections from retirement, in the sense that I now have the leisure of not being pressed by day-to-day considerations of what happens in the justice system, which rises day by day, and reflect. And I thought, first of all, what I'd say something is on the changing position of the judiciary, because I think that's where you have to begin, and actually is so clearly demonstrated by this conference. Now, there are the obvious factors that we have as our society, but which affects the judiciary. The first, obviously, is globalization. The second is the fourth industrial revolution, or the digital revolution, whatever you want to call it. Third, which is hugely influential as I think regards the judicial position on the number of cases, are migrant flows, which we must not forget. And finally, the problems relating to climate change and the environment. I'm not going to say anything specific in relation to those, but those are part of the general background. I think you have to see in relation to the position of the judiciary, and each of them affects the way our judiciary works and the justice system works. But I wanted to take more specific examples. And can I take them quite briefly? First, I think one of the great changes that has occurred is that there is now the almost universal acceptance of the rule of law. Now, of course, it means different things in different places. It's a very convenient tag, but what it does mean is that actually the rule of law depends upon the role of the judiciary, and therefore that has focused attention on a judge's role. People have seen, for example, that you can, in some societies, you can have the rule of law, which people regard as absolutely essential to disputes between businessmen or underpinning an economy. But on the other hand, they're very constrained in thinking that the judges should be anyway independent of political power. So but both visions would see each of those aspects governed by the rule of law, but a very different standing of it. Secondly, I think what has happened almost across the entire world, probably led initially by the United States in the middle of the last century, and that's the growth of judicial review of administrative action. And that is in a transitory phase at the moment. I think people have seen the judiciary as being probably as effective a constraint on executive power as Parliament, certainly in many countries. And I think it's particularly important to bear this change in mind. Now, the effect is different from country to country. Here we may have gone relatively far down the road, but we're nowhere near as far down the road as, for example, countries such as India and Pakistan, where the Supreme Courts or the High Courts have taken fairly revolutionary steps in the assertion of judicial power to create things the executive has failed to do, particularly in the area of climate change or the environment. Thirdly, it seems to me, and again arising out of the universal application of the rule of law, is the importance that has developed probably since the Second World War, but much more evident in the last 20 years, of what can be derived from charters of rights or from constitutional principles. The growth in judicial commentary and judicial expansion of those rights has been enormous, and it has profoundly affected our society. I mean, I do think that one of the great effects has been the growth in equality, in the treatment of the sexes, in the acceptance of a much more civilized society, can be traced back probably to the way in which the judiciary have developed these rights. But whether you agree with it or you don't agree with it, it has had a profound effect on the public's perception of judges. And then I think parallel to the acceptance of the rule of law, there's the acceptance to an extent of judicial independence. In most countries, people will accept independence in the sense that you must have a judge who can, without being bribed, without being influenced, can decide cases between individuals. Other states would say, well, you must have circumstances where judges can decide cases without pressure between the citizen and the state. Other states would see that that was not the role of a judge, save in very limited circumstances. And so, but both kinds of system would see the importance of judicial independence. And then I think judges themselves have started to change. I think, and people have reacted to that. I think judges have found they've had to come out of their ivory tower, if they ever lived in one. For example, in relation to criminal justice, I think judges have generally understood much more about the operation of the system than most others. But the advances in science, the advances in technology, and the rapid change in the financial and commercial markets have meant judges actually have to keep themselves up to date with these huge developments. And similarly, if you are in the field of genetics, or you are in the field of other scientific development or technological development, or you're in the financial markets, you also want to try and understand the way judges think. And so I think there is also another change, which is this much greater and closer engagement of the judiciary with other people. And then, because of the importance of the judges in this respect and the importance of the judiciary, there has been, and I think this is right, particularly in an age where deference to established institutions is on the wane, that judges are more subject to criticism. And I see absolutely nothing wrong in that. Judges ought to be criticised. We have leading academics who will criticise decisions, but I think it's also quite important that others who see the effects of judicial decisions elsewhere criticise them. There's nothing wrong in that. But, and this is, I think, a very important part of our conference, is where do you go from legitimate criticism into dispute? And I think that is into abuse. And that is actually one of the terrible problems of the modern age. I think the growth of populism, the attacks on the judiciary who are seen as a block to populism, have become a very, very serious factor in the modern age. I do not think we appreciate how much the conventions and niceties of a democratic state are so important to its functioning. If you tear the rules up, or you don't abide by the conventions, then you have a major problem. And you see this in parliamentary life. I think you see it certainly in the view that is taken of the judiciary. Once you start to abuse or criticise or try to undermine things which you may want to do for a populist cause, you are actually very gravely damaging society. And I think, therefore, this sort of change, and I'll come back to this at the end, has been very, very important in what is the theme of this conference, and the theme of quite a lot of academic research, has been really how has the judiciary had to change in relation to its relationship with the people and in relationship to the executive and legislative branches. Here we've seen it very starkly. For example, until, as has been mentioned, until 2004, the Lord Chancellor used to look after the judiciary. The judiciary did not have its own media. That was provided by the Lord Chancellor. He would, if there was some criticism of a television programme that was critical, say, of judges' sentencing policies, that would be dealt with by the Lord Chancellor's department. And in some cases, this was a very bad thing, because it sometimes, towards the end, began to suit people not to defend the judiciary in some areas. And so, as is the thesis of the book, of which Professor Kate Malleson is one of the authors, one of the paradoxes of the judicial independence and the abolition of the Lord Chancellor is that actually the judiciary has had to reshape its relationship and work out how it deals with these problems. And I think finally in the factors, and I shall return very, very briefly to this, is the position of the judges on the international plane. I think we sometimes ignore, say in Europe, the huge difference that has been brought about in extradition by a move from an interstate relationship, which is traditionally what is done across most of the world, to an intrajudicial relationship in interstate relations. The judges now deal with other judges and ignore the executive completely as regards extradition between the states of Europe. And of course, this is a highly topical subject in relation to Brexit, but I'm not going there. But of course, you can ask me. But it's reflected, I think, in a development that occurred last year, which is the creation of the Standing International Forum of Commercial Courts, where judges from courts as diverse as some in Europe, some across from Africa and the old Commonwealth and the very old part of the empire, namely the United States, got together and looked at could the judges in this area of commercial work do more to cooperate on a judicial cooperation basis rather than an intergovernmental basis. And so although one has a very concrete example of it in Europe, where a whole area has been moved to the sphere of the judiciary, I think that this is part of an underlying trend. Now, those are just some observations. There are a whole lot more things that are happening, but I think it's quite important to paint this picture of a very, very changing judiciary. Now, I think in that area, I'd just like to sort of turn next to look at what is the role of a judge in the modern age? What does a judge do? Now, obviously, and I will come back to this very briefly at the moment, a judge's principal function is to decide cases between the litigants in front of that judge. And this is of central importance to the protection of judicial independence, and I'll come back to that. But if I can just very briefly touch on a few areas to show where maybe, and this is primarily by reference to the United Kingdom, the role of the judges is expanding, and I think it's quite interesting to discuss whether this is sensible. Take access to justice. I think it's a universal problem across the world that states are restricting the amount of money they devote to justice. It may be that when I go to judicial conferences, this is the thing judges moan most about. But I think it's true. Legal aid has been constrained in many countries, and less money is available to the justice system. Therefore, what role do judges, what is the role of a judge? Should you be concerned about access to justice beyond interpreting constitutional instruments to provide rights to justice? Should judges engage, for example, in improving procedure? Should judges be concerned about making certain that when a case comes before them, there is proper advice available? I think it's something that's very important to delineate the role of the judge. But can I turn to criminal justice? Because I think another question arises there. Obviously, it is again the conduct of the trial, but to an extent, has the modern system taken judges further? And one area of concern, I think, some of it is historic, but it now really needs to be looked at more carefully, and that is the ability of the judiciary to hold other actors in the justice system to account. What is the role of a judge in holding the prosecution service to account or protecting its independence? What is the role of the justice system in providing for accountability of the police? Now, we know that in this country, in the United Kingdom, well, in England and Wales, the prosecution service is accountable to the Attorney General, but his powers of intervention as a result of what happened in the early 2000s have been to an extent diminished. And the operation of police and crime commissioners has kept police and crime commissions totally out of the operational functions of the police. Therefore, who holds these people to account? And it's been quite interesting in relation to the publicity in this country that's arisen as a result of the failure of making documents available to the defense that might help the defense or undermine the prosecution case. It is the judges who have been the most effective at trying to hold the prosecutors and the police to account. Is that their function? And a second area, again very closely related to criminal justice, is the creation of the Investigatory Powers Commission. This is a body that is chaired by an active judge, and the statute provides for this, and the commissioners have to be people who've held judicial office, who look at and examine the legality of the way in which the security services operate. Now, if I went back 50 years, there would have been, if you suggested it, you'd have been thought to be mad. The idea that the security services could operate with judicial control would have been thought as mad, absolutely mad. But we now have this system. And I think we need also to reflect on this as part of the, although the security powers, the chief commissioner may not be doing strictly judicial work, he is a judge. And this is a huge expansion here, and again modelled much on the New Zealand model, of the role of the judges. And then I need not say more about this because it's a subject that's so well known. It is the huge growth to which I've referred, to the way in which judges, through the exercise of their role in judicial review and in fundamental rights, have expanded enormously the role of the judiciary. And then finally, there is the role of the judges in upholding the constitutional balance. I don't think here there is much of a change within this jurisdiction. People had forgotten the role the judges played in the cases in the just before the Civil War of the 17th century. But actually it all came back in Miller when exactly the same sort of problem arose. So there may be nothing new in that. And so I think one has to ask oneself, looking at the factors that have affected the huge change that has occurred on a broader perspective, what are the functions? Are we going in the right direction by entrusting more and more to the judges? And I've looked at the question of the role of the judges in relation to 4 areas of law. And I could have taken others, family law, but there simply isn't time. But again, and I shall come to this now, is that there are other areas where the judges have started to exercise much more influence. One is in relation to judicial appointments, no doubt, which we will come to, and the other is in relation to court administration, to which I will briefly return. And so I do think that we have to ask ourselves the questions, and it's often quite difficult to see what is happening if you don't stand back. Is the role of the judiciary expanding because of the factors to which I drew attention first in these specific areas beyond the traditional? And to what extent is this desirable and sensible? I don't want to answer that question. That's a question for discussion, which I've tried to set. But what I do think it's absolutely fundamental to bear in mind this expansive role when you come to look at what is necessary to protect judicial independence. And it is to that I now want to make 9 points. Sorry to sound rather didactic, but I thought it might help. Now, the first thing, my introduction, before I get to my 9 points, is to appreciate, certainly in this country, that we at the moment have, and I think in most countries, the judiciary has a very large balance, favourable balance in the bank. It is one of the institutions which, and I touch every bit of wood I can look at, is that it has, of most of the institutions, one that has in this country and in many countries been seen as an institution in which the public has confidence. And it is critical that that confidence is retained. So how is it done? And again, this is the subject of it, but can I make my 9 suggestions? First, and absolutely central to the maintenance of judicial independence, is that the judges do efficiently that which has been assigned to them and properly, and therefore deciding cases quickly, cheaply, and justly is absolutely central. Any judiciary that ignores that fundamental principle is immediately in trouble. And one only really has to look to what happened in Poland to see how the government there has used criticism of the public as a way of undermining the judiciary. And it is, judges sometimes overlook that fact when they see the attack made by the Polish government, and serious the attack is, on the fact there was a lot wrong with the Polish system, and so it was possible for the government to blame the judges. Secondly, I think, and I don't want to go into this because I spoke about it at quite considerable length in a lecture I gave in Jerusalem last year, is that the judiciary needs a proper scheme of governance. This is a subject that is not much studied, but it is absolutely central. You have a proper scheme to govern the judiciary. It is, after all, a branch of the state. And if you have any branch of the state that is not efficiently run, and this applies as much to the legislature as it does to the judiciary, if it's old-fashioned, it doesn't deal with things in a modern manner and doesn't govern itself properly, then it is in deep trouble. And so, you know, one could be critical of Parliament and say that there's an awful lot wrong with the way in which it works. But my subject is the judiciary, and I think that it is absolutely right. You've got to have a very clear system of governance, and there are 3 things you have to take care of. One, the governance has to have a representative element which marries to what is inevitable in any judicial system, which is a system of hierarchy, because you have hierarchical courts. Secondly, it has to protect the independence of each individual judge. You cannot have save within the confines of an appellate system, a hierarchy of the judges, which effectively tells individual judges how they should decide cases or gives them a steer. The protection of individual judicial independence is absolutely central. But then you have to have a leadership that is capable of ensuring the system runs efficiently. It's quite a big subject, but I just wanted to mention it. Then I think the third thing judges have to do is actually where the system needs modernizing, then it has to, the judiciary have to play a leading role in modernization. One forgets, or most people forget, that probably the greatest Chief Justice in this country, or certainly one of the greatest, was Lord Mansfield. And although he's known for his great contribution to the development of our commercial law, and also the decisions he made in relation to the status of slaves and other matters, he was also a great reformer in bringing the system out of the terrible technicalities of the times when he was appointed. And at the present time, the responsibility of the judiciary to modernize, to cope with the advent of the Fourth Industrial Revolution is enormous. The fourth area is the question of court administration. Now this is an important topic. Again, I only want to touch on it very, very briefly. To anyone who works in a judicial system, the way in which the administration works is critical, partly because it affects the efficiency of the system, partly it affects its independence, because you want to be sure that the way cases are allocated is fair and proper, and partly because if you have an administrative system that isn't within the control or influenced by the judiciary, then you can have terrible problems of morale. Now, there are a whole host of different solutions to this problem, and it's probably the area that varies most from state to state, even within the United Kingdom. The Scottish judiciary has and the Irish judiciary in Ireland have a much greater degree of control over the court administration than in the UK, than in England and Wales, simply because in those countries the administration is responsible to the judiciary in its entirety, whereas here there's a joint responsibility. And so, or you go to Germany, where almost all the court administration is, although nominally under the supervision of the judges president in courts, the administration is provided by the state. And there's a huge variety across the world. But it is something where you have constantly to look at, is the administration furthering the interests of justice, and do the judges have enough influence about it? The fifth factor, which I think is important to the protection of judicial independence, is the whole issue of appointments. Now, I could spend, or could have devoted the whole of this lecture to appointments. There are the issues to ensure, for example, that you have proper entry into the judiciary, that you recruit correctly. There's the whole issue of how you move people up the system, and how you encourage a judiciary that is reflective of society. But at the same time, you make certain that it is fit for purpose. It is a very, very difficult area. Countries take many different solutions, and there is the area which has recently been ventilated, is have we gone too far in this country in removing any executive influence over appointments? It is very, very small in this country, whereas in other countries it's much greater. If you contrast this country with Trump's America, the difference is striking. No British Prime Minister could conceivably appoint judges on a basis that might influence beyond any possible term that the Prime Minister might have, whereas President Trump is able to appoint relatively young people who can be there for a very, very, very long time, with views that might be not entirely reflective of the whole of American society. But these are different systems, and I think that it is an area where, in protecting judicial independence, I think, would take the view that you must try and ensure that the appointment system operates without undue political influence from the legislature or the executive. But on the other hand, I do see that there is an argument you must have some input to create its legitimacy. But this is a subject that is too great for me to go into beyond saying that it exists. But it is one of the factors that is essential in protecting judicial independence. The sixth factor is public accountability. And I think that until very recently indeed, probably the early part of this century, and I do mean the 21st century, judicial accountability was seen as really the doing of justice in public and an open appellate system, giving reasons. But I think that now that judges have taken on more responsibilities, they have an accountability for that. I used to find when discussing accountability with other judges in Europe, in say around about 2005-06, that this was not a concept that people were prepared to think about. I think now there has been a huge movement towards accepting there is an accountability for the non-judicial functions of the judiciary, namely, for example, court administration, the efficient conduct of business. If the judiciary takes the responsibility for the efficient conduct of business, it has to be accountable for it. And to my mind, an explanatory accountability showing what is happening is absolutely central to maintaining judicial independence. And then there comes communications with the media and the relationship of the judiciary to the media. This is again a huge subject, and I know you're coming to it, but I wanted to make, I think, one observation, that getting this right is absolutely important. And one of the areas of tension at the moment is to the extent to which you should allow things to be broadcast or recorded. Now, we took very, very tentative steps in this country in allowing appellate cases to be broadcast, but the steps are very tentative. I have not met anyone who doesn't think that the televising of the Article 50 case in the Supreme Court was anything but wonderful. It did the judiciary a huge amount of good. But the way in which we approached this meant that it was impossible, because of the jurisdiction of the divisional court, to televise that. The technical reasons for that someone can ask me about, but it's boring and I don't want to be distracted by going into it, but it couldn't be done. But we have to stand back and think. I think on the one hand, you can take the view that you must not add where you have oral testimony to the pressure on witnesses by televising them. But on the other hand, in an era where people like to see the person who makes the decision actually visually giving it, why don't we televise, for example, the giving of judgments? They do that in the Supreme Court, the making of sentences, the return of verdicts, matters of this kind. It can be done. There's a huge opposition to it. But I think that opposition is unreal because across the world there is the media revolution where local papers that report in courts are on the decline. And shouldn't we now completely look at this again? I mean, sometimes some of the large press agencies say, do you appreciate we will only survive if we can move into a modern media? And then my eighth factor to think about that needs to be thought about in this context is relation with the public and with communities. Now, judges have, I think, traditionally always spoken at universities, spoken to law schools. It's something, it's always nice if you're an old man to go and talk to the young. But outside that rather self-indulgent view, I think it is now accepted that judges need to engage so that they understand and can help people understand the way our system works. One of the great successes in this country has been the development of the system of diversity and community relations judges. It has done something to directly engage the judiciary with the communities. And there is quite a lot of evidence, some of it not well known, how beneficial this has been. And I think that that is one huge important factor for judges to look at. The next is one I've touched on, which is making certain that judges understand the modern world, that is science, technology, and are at the forefront. For example, one of the really difficult areas for a judge is making certain you understand the basics of science, or you put things in place to make certain you get proper scientific evidence before the court. And in this country, one of the things that I think has helped greatly in relation to this particular problem is the work done by the Royal Society in its production of primers to make certain that the basic science in matters such as DNA is available. And that's been a judicial cooperation with the Royal Society in producing something that gives you a firm foundation in the modern world, and so the confidence in the judiciary cannot be undermined by a misapplication of science. And then finally, and the ninth thing, is the international engagement of the judiciary. I've already touched on it. I cannot tell you how much judiciaries learn from each other. My whole experience has been that actually most judiciaries face exactly the same problem. No money, poor facilities, how do you harness the digital changes? And for example, the press. I mean, when the Lord Chancellor's department ceased to be the department that provided the public relations for the judges, the press relations, this country adopted the system that had been developed only a few years before in the Netherlands. And so there is a huge amount to be gained from learning. Secondly, I do think that judges across the world owe a duty to support one another when they're taking difficult decisions and are under huge pressure. One, I think that the very brave decision taken by the Kenyan judiciary last year, or a few years ago by the Pakistan judiciary, do need support. And it's quite a tricky issue, but it is very, very important that judges support independence. But I do think that, on the other hand, you have to beware as a judge in this sort of area, and therefore is actually being, if you come from a judiciary which is regarded as very independent, being used by another judiciary which is not independent as a supporter by going there, by being photographed as saying, well, they're perfect, they're just like, look how independent we are. These judges come here and say nice things about us. It's a difficult area, but it is one that I think we have to carefully think about. Now, those are factors, and there may be many others that one ought to examine to ensure that we are vigilant about judicial independence. It is a much broader canvas than we would, I think, traditionally have looked at. But I wanted finally to return to really what has traditionally been at the core of judicial independence, which is its relationship with the executive and the legislature. And I think that the concept of judges in most Western democracies of being independent, whatever the system of appointment, and if you can in most countries where the executive or the legislature plays a huge role in the appointment process, nonetheless have a very independent judiciary. And I've heard presidents of states say, I know I have this great role in appointment, but I'm convinced as soon as people are appointed, they become independent. And so the maintenance of that independence, I think, in the centre is understood. But I do think we don't pay enough attention to what I would call interdependence, which is the role and the relationship between the judiciary and the other two branches of the state. It's a phrase coined in the United States by Justice Jackson in the middle part of the last century, that the organs of the state, the judiciary, the legislature, and the executive have to work closely together. And that's quite difficult. You have, I think, to have a proper and clear understanding of the constitutional functions and responsibilities. This is a very difficult problem, as I shall come to in a moment. Secondly, you have to have mutual support. So if one institution, one part of the way the Constitution is operated, one branch of it is under attack, another part will support it if it's doing its correct constitutional function. And thirdly, I do not think one branch of the state should interfere in the proper working of the other branch of the state. Now, that is fairly easy to state, but it is bedeviled by a number of problems. First of all, I think that we have not spent enough time teaching people the niceties of the conventions of the way our Constitution works. There is insufficient understanding of the functions and operations of another. Say 100 years ago, you would have found that many of the people who were prominent in government or prominent in Parliament were busy practicing lawyers. That isn't the case anymore. It is very, very difficult to do anything that becomes an MP. And if you go back to the way in which life has developed, there are still a lot of lawyers in Parliament, but most of them have left practice maybe 4 or 5 years ago, and practice has changed. And so there is, if you just look at that, a surprising lack of understanding of the contemporary problems. But equally, judges are equally ignorant of the niceties of parliamentary procedure. It is evolving and changing all the time. And again, within government, it is very surprising, but we try and do as much about it as we can, which is to educate those who occupy quite senior positions in the civil service of how judicial independence works. We're hugely helped by the government legal service, but it is an educative process. And I think that it is of critical importance that people understand the roles. It enables, for example, judges then to engage in some of the difficult issues. I mean, if I can just go to Brexit for one illustration, Lord Justice Hamlin chaired a committee that looked at the implications for the UK of the departure of the UK from the Brussels Conventions. What did you put in its place? And it was possible to do that in a way where what the judges tried to do was set out the options, the pros and cons, but without telling the government what to do. And this quite often happens in sentencing work, that you try and tell the government, well, these are the options, it's for you to decide what to do, but it depends on a subtle understanding. Secondly, I think it's very important that politicians and others come and see how the courts operate. And I think that it's very, very important that ministers have to rely very much on the civil servants for the advice and understanding that they have, so that when a decision is made, and from time to time that the judges make a decision that the government dislikes intensely, that they say, we don't like that decision, we think was not correct, we shall appeal. They don't go and abuse the judges for it. And so I think that this subject of interdependence, of a proper understanding of the relationship, and actually working together, and it begins to address a subject which I've gone nowhere near, but it's safe to pass it, which is what is called judicial self-restraint, or because that is in essence merely an application of an understanding of the proper role of judges and the proper role of the legislature. I'm afraid that's been a whistle-stop tour. I hope I've not gone too quickly. But I hope it will set in general the background for this conference. I know we're going to revisit these areas in some detail, but I promised Yvonne I would allow a few minutes for discussion and questions if anyone wanted to ask any, or if not, there's always coffee or tea or something.
3 words attributed to the Labour Prime Minister of the day, James Callaghan, or as he was affectionately known, Sonny Jim, were said to have caused the fall of the government. There had been a run on the pound in 1975 and again in 1976. Chancellor Dennis Healey was forced to go cap in hand to the International Monetary Fund for a rescue loan. Inflation was running at 10%. The government sought to impose a pay cap increase in pay of 5%. That failed pitifully. Strikes abounded. refuse collectors withdrew their labour, petrol tanker drivers refused to make deliveries. And the lasting images from that time are of rubbish in the streets and reports of bodies lying unburied in mortuaries. The Prime Minister, Mr. Callaghan, in the midst of this turmoil, went to an economic conference in Guadeloupe in the West Indies. He returned looking relaxed and tanned. Actually, his general disposition, I think, was pretty relaxed. But in any event, he looked extremely relaxed. And of course, he was assailed at the airport by a horde of reporters demanding his comment on the emergency that gripped the country. And he was reported the following day as having said, "Crisis? What crisis?" It appears that in fact he didn't say that at all. Those words were a confection of a Sun journalist. But they caught the mood of the nation and the government fell. In fact, if you're interested, what Jim Callaghan actually said was, "I don't think other people in the world would share the view that there is mounting chaos," which is probably an ambitious enough claim too, but certainly wasn't succinct and crisp enough for the sub-editor of The Sun. I reflected on this when I was given the topic to address today, and it seems to me that there are at least two lessons to be learned from the story, not least the susceptibility of the general polity to influence from imaginative press reports. That, you may be relieved to hear, is not something that I intend to dwell on today, at least not other than obliquely. But two particular messages germane to today's conference can be taken from that experience. First, that what qualifies as a genuine crisis is difficult to judge in contemporary experience. Second, that one man's crisis is another's challenging opportunity. Reflecting on it, I think there possibly is a third lesson to be learned, and that is that our reaction to crises, perceived or real, is ultimately the true measure of the relative success of the discharge of our public duty and the contribution that we make to a properly functioning democracy. So let's look first at what we mean by crisis, keeping in mind that history is the only reliable judge of what that elusive concept might mean. There are those who would certainly suggest that the significant political uncertainty that we currently face over Brexit constitutes a crisis. Well, whatever of that, it certainly presents a challenge. And a challenge, I suggest, for all the institutions of government, legislative, executive, and judicial. In fact, I take leave to doubt that it truly is a crisis. But it unquestionably has shown a... Am I putting something off? No, well, perhaps not. So something risque doesn't come up and it's dead. In any event, it's unquestionably shone a spotlight on the various roles that each of the organs of government has been and will be called upon to perform. And there have been occasions when the way in which the various institutions have been scrutinized or even criticized that partake of something approaching censorious commentary on the roles that we played. Well, I perhaps am being unduly sanguine here, but I don't really think that this constitutes a crisis. But just to let the discussion flow, let's pretend that Brexit represents a crisis. And let's imagine that criticism of the judges in the divisional court and their portrayal in a certain newspaper as enemies of the people constitutes a crisis of trust in the judiciary. And ask ourselves the question, how should we react? Well, in my view, with relative calmness and equanimity. There are certain unalterable truths about the judiciary in this country that not even the most vituperative of commentators are likely to question. First, we are fortunate to live in a society where corruption and bribery are not features of our legal system. Economic and political interference with the exercise of judicial duties are not concerns here in the way that they are in other jurisdictions. But that doesn't mean that we should be complacent about the importance to be attached to judicial independence. Although I hope it is, and it certainly should be, regarded as a given, its preservation, the preservation of judicial independence is not less than vital. And the contours of the exercise and assertion of our independence need constant reminder and, if necessary, renewal. Let me put that in hopefully a slightly more comprehensible way. Will it make a terrible difference if I put this down? Hopefully not. What we need to remind ourselves of is that as judges, our role can shift and change as the constitutional order alters, and as our understanding of our greater contribution and reaction to those changes develops. But some fundamental features of the judicial role and experience are, of course, unchangeable and unchanging. It's axiomatic that we must discharge our duty in a wholly independent, scrupulously impartial, and conspicuously fair manner. Of course, the traditional template for the preservation of that independence is adherence to the fundamental constitutional principle of separation of powers. But aspiration to adhere to that principle provides, as I have reason to know, endless opportunity for lively debate and ongoing controversy. Of course, in the early cases, well, I say early, it's not all that early, but the case of McGonnell against the United Kingdom, which came before the European Court of Human Rights in 2000, the answer was easily found. That was a case in which the principal judicial officer in Guernsey, who'd sat on the appellant's case, was a senior member of all three branches of government, the judiciary, the legislature, and the executive. So the European Court of Human Rights was not, I think, unduly taxed in holding that the otherwise quite admirable versatility of this individual didn't exactly chime with the notion of a true separation of powers. The discharge of his judicial role was not marked by the requisite appearance of independence and impartiality, and the situation therefore breached Article 6 of the applicant's convention rights. More recent judicial debates in this area present us with rather subtler or at least more nuanced problems. What role is there, if indeed a role remains, for deference by the judiciary to governmental decision? What is the influence that so-called institutional competence has in the review that we conduct of legislation, both primary and subordinate? Whether intensity of review and anxious scrutiny? Well, I hope that deference, at least in its conventional connotation, has received its quietus. In a number of recent decisions in the court of which I am a member, we have addressed that issue. And my colleague Lord Sumption put it very well, I think, in a case in 2014, Lord Carlisle of Berriew, when he said, as a tool for assessing the practice by which the courts accord greater weight to the executive's judgment in some cases than in others, the whole concept of deference has been subjected to powerful academic criticism. At least part of the difficulty arises from the word, with its overtones of cringing abstention in the face of superior status. In some circumstances, deference is no more than a recognition that a court of review does not usurp the function of the decision maker, even when convention rights are engaged. But beyond that elementary principle, the assignment of weight to the decision maker's judgment has nothing to do with a deference in the ordinary sense of the term. It has two distinct sources. The first is the constitutional principle of the separation of powers, and the second is no more than a pragmatic view about the evidential value of certain judgments of the executive, whose force will vary according to the subject matter. Sadly, he didn't agree with me in that case, but I certainly agreed with that passage. Beyond reservations about the appropriateness of the term, deference, however, there's no general consensus. No general consensus among the members of the Supreme Court has emerged about the role of the court in reviewing government decisions in the public law field. As I'm sure most of you will know, that over recent years we've entertained legal challenges to the bedroom tax, to employment tribunal fees, to restrictions on legal aid. And in those cases, and I'll mention one in particular in a moment, a variety of approaches to the question of the level and nature of judicial review to be exercised can be discerned in the various judgments of the members of the court. That diversity of view was perhaps best exemplified in the case of Nicholson, colloquially known as the assisted dying case. A very tragic case, of course, and a panel of 9 justices, which is relatively rare, had the case. Of those 9, 2 felt that the courts could and should declare the current law incompatible with the right to respect for private life under Article 8. At the other end of the spectrum, 2 felt that the law in this area was a matter for Parliament alone, and that the court should not consider making a declaration of incompatibility under any circumstances. And the others fell somewhere in between. There is a good deal of commentary about the impropriety of, as they're frequently referred to, unelected judges second-guessing Parliament and the executive in matters of social policy. Now, I do not accept that this is what has happened, or that there is a realistic prospect of it occurring. And I set out my stall on this question in the Nicholson case when I said an essential element of the structure of the Human Rights Act of 1998 is the call which Parliament has made on the courts to review the legislation which it passes in order to tell it, that's to tell Parliament, whether the provisions contained in that legislation comply with the Convention. And by responding to that call and sending the message to Parliament that a particular provision is incompatible with the Convention, the courts do not usurp the role of Parliament, much less offend the separation of powers. A declaration of incompatibility is merely an expression of the court's conclusion as to whether, as enacted, a particular item of legislation cannot be considered compatible with the Convention right. In other words, the courts say to Parliament, this particular piece of legislation is incompatible. Now it's for you to decide what to do about it. Or indeed, I should have said, whether to do anything at all about it. Under the scheme of the Human Rights Act, it is open to Parliament to decide to do absolutely nothing. What the courts do in making a declaration of incompatibility is to remit the issue to Parliament for a political decision informed by the court's view of the law. And the remission of the issue to Parliament does not involve the courts making a moral choice which is properly within the province of the democratically elected legislature. And what I was trying to drive at there, the essential point that I was trying to make, is that in reviewing legislation, we're doing no more than what we have been asked, indeed enjoined by Parliament to do. And it doesn't seem to me that there is anything whatever untoward about it. But it does seem to me, and I think that this is a point not often made, but well worth making, it does seem to me that the willingness of the democratic institution that is Parliament, prizing, as it rightly does, its sovereignty, its decision to allow its measures to be tested by the court for their coherence with the European Convention on Human Rights, is a remarkable constitutional statement. It's not less than an acknowledgement by Parliament that an external, apolitical, and impartial agency should be able to consider the lawfulness of its actions. That decision of Parliament in enacting the Human Rights Act of 1998, with it is to be remembered strong cross-party support in both houses. That decision to allow its legislative measures to be subject to scrutiny by independent courts is an historic constitutional landmark. It accorded to the courts an enlarged and vital role in reviewing actions of government. And as many of you will know, the discharge of that role is sometimes described as the realization of a bipartite democracy. Now, the notion of bipartite democracy precedes by a very long period of time the 1998 Human Rights Act. That notion is by no means a new one. Its fundamental nature has been recognized in the writings of Lord Steyn, Ronald Dworkin, and Lord Justice Laws. But perhaps its essence is most neatly captured in a judgment of the very distinguished former president of the Israeli Supreme Court, Aaron Barak, when he said, "Democracy is not only majority rule, democracy is also the rule of basic values and human rights as they have taken form in the Constitution." Democracy, he said, is a delicate balance between majority rule and society's basic values which rule the majority. Take majority rule away from constitutional democracy and you have struck at its very essence. Take the rule of basic values away from constitutional democracy and you have struck at its very existence. I venture to suggest that the important interplay between the vindication of basic values and majority rule will be a perennial feature of our constitutional democracy, and that the courts will remain the inevitable arbiter of those disputes. But I'm conscious that many commentators emphasize what I might describe as the negative dimension to the way that our present system of judicial review functions. Some suggest, as I've said already, that unelected judges wrongly arrogate to themselves power to review decisions which lie properly in the province of democratically elected ministers and members of the legislature. Now, it's no part of my purpose to seek to deny the right of those who hold those views to express them and to express them forcefully, nor indeed do I, on this occasion, seek to challenge them. Rather, I'd like to make a more fundamental point that is frequently, I think, lost sight of in the discussion that surrounds this subject. It should not be forgotten that if they are operating properly, all the institutions of the state, executive, legislative, and judicial, share a common goal. They are, au fond, embarked on a joint endeavour, and that is, of course, to improve the lot of the society which it is our privilege to serve. And it seems to me that into the debate as to how well or otherwise the doctrine of the separation of powers is operating, the fact that government decisions are, in appropriate circumstances, subject to independent verification, to a system of impartial proofing by a body of women and men of integrity, is not only an added guarantee of the soundness of decision making, it is something which, if it is properly carried out, should be a source of reassurance rather than resentment on the part of the decision makers themselves. Thank you very much for listening.
Based. It's an argument that I developed in the project referred to, the Judicial Independence Project, which I undertook with colleagues Robert Hazel, Graham G. and Patrick O'Brien. Over a 4-year period, it was a large funded empirical project looking at the effects of the major constitutional changes, started with the Constitutional Reform Act in 2005 and other legislation, and to think about the consequences of those constitutional changes for judicial independence and indeed judicial accountability. The research, the findings, was based on interviews with over 150 stakeholders, if you like, that is judges, politicians, civil servants, practitioners. And what we really wanted to try to do was to understand the day-to-day processes, the negotiation, the interaction between the judiciary and the other branches of government. Because a central feature of the constitutional changes, which some of you here will be very familiar with, was to create a greater structural separation between the different branches of government, between the judicial and the political branches, through, of course, the creation of the new Supreme Court outside the House of Lords, the creation of the independent judicial appointments commissions, and the radical changes to the role of the Lord Chancellor, which Lord Thomas adverted to, no longer being head of the judiciary, no longer sitting as a judge, no longer being a member of all 3 branches of government. And we argued that these changes had the effect, paradoxically, of requiring that there should be greater, closer, more regular contact between the branches of government. We felt that what the research showed was that the greatest risk to judicial independence in the UK in the future lies not with politicians seeking directly or explicitly to interfere with the work of the courts and the judges, but rather with their increased disengagement with the justice system, with the judiciary, with downgrading the relationship that they have with the judges. So the central claim of our work is that, far from standing apart from the political realm, judicial independence is actually a product of it. It's defined, it's protected through interactions between judges and politicians. In short, judicial independence is a political achievement. And more broadly, our findings confirmed that, in the UK at least, at the moment, judicial independence is not a fixed concept. The core of judicial independence is decisional independence, and Lord Thomas outlined that very clearly. The need for individual judges to be able to decide cases according to the law, free from any inappropriate pressure, either internal or external. But around that basic core, particularly in relation to institutional independence, everything else is negotiable. And what our research found is that it is indeed regularly, continually being renegotiated. We also concluded that judicial independence in the UK cannot be left to the judiciary alone. And indeed, nor is it simply the responsibility of one or two key politicians, political actors. Indeed, what it requires is multiple guardians. Guardians in the executive, in parliament, in civil servants, and indeed increasingly in the new group of lay people who are involved, for example, in the judicial appointments commissions. We found that Parliament is increasingly a central guardian of judicial independence, particularly through the system of select committees, where the different aspects of the work of the judiciary and the courts is scrutinised. And judges, as many of you will know, regularly now appear before committees. And the judiciary really deserves credit for its willingness to embrace those appearances. It's not comfortable, it's not always easy, they're sometimes given a rough ride, but the judiciary has been very much up for engaging in this way. And what we found, talking to both sides, is that it's clear that this is an incredibly valuable dialogue. Judges are called to account for their work through the parliamentary committee system, but they also have the opportunity to educate and inform politicians about judicial independence, and that is increasingly important for many of the reasons that Lord Thomas talked about, with the reduction in the number of legally qualified or legally informed political actors. In relation to the relationship between the judiciary and the executive, we found that many judges are still in mourning for the loss of the old-style Lord Chancellor. They saw him as the effective buckle between the judiciary and the political branches. And it's certainly true today that the Lord Chancellor is now much like any other Minister of Justice, again as Dimitrios mentioned. The Lord Chancellor has lost their special status. But despite this, we concluded that overall the judiciary and judicial independence has in many ways emerged stronger from the constitutional changes. And that is partly to do with, again, things that Lord Thomas touched on, the fact that we have now a much more formal, more well-organised internal judicial management structure. The Lord Chief Justice has much greater autonomy as the new head of a much more professionalised judiciary. I think it can be said that the Lord Chief Justice is in fact the new buckle that binds the judiciary and the political branches of state. We also examined the other side of the coin to judicial independence, that of accountability, again, which Lord Thomas touched upon. And we found that the judges now enjoy much greater powers than they once did over judicial appointments, over the complaints and disciplinary system, over judicial deployment, over the court services. And the consequence is that inevitably they must give a much fuller account of their stewardship to government, to parliament, to the legal profession, to the media, and indeed to the wider public. And we were particularly impressed that Lord Thomas took this accountability requirement very seriously, and in particular that he decided to produce to Parliament a much fuller account in his annual report of the work of the courts, and we think this was particularly valuable. Perhaps our most controversial finding, and I think the one which the judiciary found least palatable, relates to the judicial appointments process. Again, as part of the radical changes, the judicial appointments process was effectively removed from the Lord Chancellor in practice, given to a new Judicial Appointments Commission for England and Wales, and there is another one in Northern Ireland and Scotland, and a separate ad hoc commission for the Supreme Court. We found that the Judicial Appointments Commission for England and Wales is now a very efficient recruitment agency, but the judiciary has much greater influence than it once did at all stages in the process. The Lord Chancellor's role has pretty well been reduced to that of a rubber stamp. Now, of course, that has the advantage that it reduces any danger of crude political interference in judicial appointments. The disadvantage is that it undermines attempts to improve judicial diversity. As probably everyone here knows that for many years there has been a very clear, very strongly expressed consensus amongst politicians and judges that the extreme lack of diversity in the judiciary and the composition of the judiciary, particularly at the higher ranks, needs to change. I recently counted up the number of official reports there have been into the lack of judicial diversity and counted 16 since 1999. They are astonishingly similar. But despite this, progress has been glacial. The problem is now so serious and so entrenched that it will require political will to change. And that political will is in truth very unlikely to come from the judiciary. As long as the judiciary has considerable influence at all stages in the judicial appointments process, the tendency towards self-replication in appointments is inevitable. And that's not to criticise the judiciary. The fact is we all tend to see the best candidates as those being people who are most like ourselves. It's an inevitable and natural human tendency. So if there is need for political engagement with the appointment system, as there used to be under the old system, it's important to remember, there is need now to really think hard about what that means and what is required. At the very least, I believe that the Lord Chancellor should be given a real choice through a shortlist of perhaps 3 names provided by the Commission in relation to at least the senior judicial appointments. At the moment, the threat to judicial independence in the judicial appointments process doesn't lie with the danger in the UK that politicians will try to appoint judges who crudely support their policies. Lord Thomas was right to contrast the US and the UK in this regard. Instead, I think the danger is that the continuingly gross, unrepresentative composition of the judiciary is likely to undermine public confidence and legitimacy. And as we know, both of those are the vital foundations on which judicial independence rests. Thank you. I think I would say that, but I think it also comes back to my point about multiple guardians. I don't think you can any longer expect one person to take that responsibility. Clearly, the Lord Chief Justice takes the lead now. That's the reality. The Lord Chancellor has a statutory and indeed constitutional and conventional responsibility to respect judicial independence and needs to be regularly reminded of that. But I think it is now much more of a collective role that we all need to engage through the media, through each other, in reminding the Lord Chancellor of the need to respect that. I also think one of the other things that we found in our research, which I didn't really touch on, but I think was interesting and slightly unexpected, was that personalities still play an enormously important role, individual personalities. And despite the fact that it's a much more formalised, much more professionalised system, you might think that that therefore was less the case. But actually what we found was that the personalities and the particular approach of individual Lord Chancellors, of individual Lord Chief Justice, of individual civil servants, of the individual head of the Judicial Appointments Commission, etc., actually still matters a lot. So there's much more ebb and flow about these things than I think one would necessarily expect.
And Kate, I have actually 2 questions that occurred to me listening to you. One was, in your findings in this judicial independence project, one thing that really struck me was how the research process itself actually gave rise to a lot of this dialogue that struck you as being particularly important between civil servants and between the judiciary. And I suppose in reading it, I wondered, is that really the role of us as academics to facilitate that dialogue, or is there some other way that we can make sure that that dialogue becomes ongoing even beyond the scope of a research project?
Yes, thank you. Yes, we ran a number of seminars based on Chatham House Rule, and a lot of senior members of the judiciary, of politicians, civil servants, lay people came, and I think it was helpful. But I agree with you, I don't think that structurally is a viable ongoing method for promoting that conversation. I think it may perhaps been just that it was useful because of the particular time, arguably a transitional time in the early years, which I suspect we're now moving out of. But I think that is a real challenge for the judiciary to find ways to make sure they keep those conversations going. It was an awful lot easier in the old days when a Lord Chancellor used to walk in on his way to work before breakfast and just go and chat to the Lord Chief Justice as a matter of course. That was just a way of keeping that conversation going. That just isn't available anymore. And I'm sure that the judges in this room will could talk about and tell us about the ways in which they're working hard to do that. And I think civil servants are actually also very conscious of it and ensuring that they provide means. So I think new and innovative ways have to be found. I agree, I don't think academics can fill that gap.
Thank you. We'll go to Judge Quinlan.
Historically, Lord Chancellors tended to be in office for most of the duration of an administration. And they were people with sound knowledge of the law and functions of the court. Their long periods in office allowed them to learn their job. We've been in a position recently where how many Lord Chancellors can you name in the last 3 months? When I was Treasurer of the Inner Temple last year, or the year before, I had 2 Lord Chancellors visit me during the course of my 1 year in office. But one of the problems might be that the legislation which changed the appointment of Lord Chancellor identified that the Lord Chancellor should be someone with suitable knowledge wasn't something which, or suitable experience, wasn't something which was sufficiently specific, and that government hasn't appropriately learned the advantages of having somebody in office for longer duration and of sufficient weight. Do you think there's much in what I've just said?
I think there's a lot in what you've just said, but I think one needs to separate out 2 different issues. One is the question of whether the Lord Chancellor needs to be legally qualified and what that means, and the other is the point about the fact that they are now on their way somewhere else. And actually, initially, I think I was more concerned about the legal qualification point, but having spoken to, the more we spoke to people, and then what we've witnessed since, actually I think the second point is more of an issue. Whether or not the Lord Chancellor is legally qualified, if they are there for a while, and if they have good civil servants, and if they talk to judges, they're usually reasonably smart people, they can get it quite quickly. That isn't usually the issue. The problem actually is that Lord Chancellors in the old days, the old style Lord Chancellors, were at the end of their career, essentially. They had nothing to prove, they were not looking for promotion, and therefore they could stick their neck out, and they weren't on their way somewhere else. They are now, of course, mid-ranking politicians, and that I think really does change issues, the fact that they are not there for long enough. Now, of course, it's a double-sided coin, because what it does also mean is that, of course, judges are there for the long term. And astute judges can sit it out to some extent. Well, this Lord Chancellor is annoying, but this Lord Chancellor probably won't even be here in 9 months' time. I will. And we know there is some advantage, and that makes it sound like it's a very adversarial relationship, and it isn't. Often the relationship works very well. But where it doesn't work well, sometimes the advantage is in those who are there for the long term.
David.
I have 2 questions about the relationship between the diversity problems on the bench and judicial independence. So the first is, when you say that you think that disengagement with the judiciary is biggest, is that entirely because of this problem of lack of diversity on the bench, or are there other ways in which you think that disengagement by political branches of the judiciary threatens judicial independence?
Oh, no, absolutely not. Issues, and again, I think the judges here are better able to highlight those, but the obvious one is funding. If you really don't get why the courts really matter, why access to justice really matters, then of course when there's the next funding round you're likely to just say, well, here's something easy to chop, and who cares? Who cares about civil justice? You're not going to lose any votes, are you, if you chop the civil justice system? And it's actually, in many ways, that risk is where I see the real threat. Whereas if politicians really understand why justice systems matter, then they may well, around the cabinet table, fight as hard to retain the civil justice system and to, you know, argue that perhaps the military budget could squeeze a little bit more.
I see two hands up over here, so if it's okay with you, we might take two questions.
Yeah, absolutely, yeah.
I was just about to come around to funding, and it's certainly not a party political issue, because I think every party of every colour is not particularly keen on funding anything.
Yeah.
But there's a lot of talk about access to justice for litigants because of funding. But that judicial diversity also depends on funding, because we've had a period where it has been more accessible to have a career in law to people from diverse backgrounds. But if a career in law requires extensive personal investment to become qualified as a lawyer, and then, particularly for the criminal side of the profession, earning very little money for a long period of time, it is almost automatically going to be self-selecting to the rich.
Yeah.
How does one deal with that?
Yeah, I think you're absolutely right. There are critical questions here about legal education and funding. I speak for the university sector, I think has been quite irresponsible in not addressing this and not thinking about this. Lord Thomas raised issues around how do we engage with that. Do we need to think about apprenticeships, etc.? The bar has been equally irresponsible. There was, as you I'm sure are aware, attempts to set up proper pooled scholarships centrally were just resisted by, to put it crudely, the richest chambers, actually. So the redistribution has to go on at a whole range of different, you know, it has to go on at the universities, it has to go on government level, it has to go on in the legal profession. Solicitors, city solicitors have also failed to play their part in this. So there's multiple levels. But ultimately, if we're talking about diversity in the senior ranks, which is where the real problem is, then of course you've got to also look at who is the candidate pool. And at the moment, the candidate pool is still QCs. And if you look at if we just take gender, if you look at the proportion of women who are appointed at QCs, it is still shocking. I mean, the figures, when I last looked, it had moved from 10% of appointments being women to 14% over 12 years. Now, if that's the sort of rate of progress of the change at QC level, then the QC simply cannot continue to be the main pool from which senior judges are selected if you are serious about changing in relation to gender, for example. So there are multiple different levels, but I absolutely agree with you that the legal profession, for many different reasons, and not just for the appointment of the judiciary, there's no question that it's becoming less diverse, less accessible because of funding.
I'll take one final question.
Very briefly, we touched on the reforms of the Office of Lord Chancellor. One thing perhaps we've missed is the reform of the ministry that's associated with that office. And I just wondered what your thoughts were on the actual focus of that ministry now, because back in 2003, before the reforms, it was essentially responsible for a small number of things, judicial appointments being one of them. It's now responsible for prisons and various other issues, which actually in budgetary terms is much larger in terms of the focus. How much do you think that impacts on the issues that we're discussing today?
I think potentially very seriously. I think that change was deeply problematic. And as I understand it, that judges really have struggled to keep the courts and the judiciary up there with prisons, given, as you say, it's such a relatively small part of the budget. The only thing to be said against that is that at least it means that you're in a heavyweight department. And of course there was always a danger that if the Lord Chancellor's department, as was, had continued in a similar form, it might have slipped further and further down the chain of importance. It comes back to the issue of who the Lord Chancellor is, and again cuts both ways, because on the one hand, having a politician who isn't a lawyer, who's based in the House of Commons, not the House of Lords, who's halfway through their career, raises serious problems. On the other hand, it means you often do have a really strong political actor at the table, and certainly we had interviewees who said to us that particularly at the time of, say, Jack Straw and Faulkner, that having those strong politicians there was actually helpful in some ways.
Okay, we'll take one final question. Thank you very much. Maybe we can address it over lunch. Kate, all that remains is for me to, again, thank you very much for this really wonderful presentation. I think your research has, I speak for myself, but I think for many of us in this room, when I said that your research has really informed our thinking on judicial independence, so we're really grateful to you for taking part. Thank you.